Today, we're jumping into the often complex world of intellectual property law. Specifically, we're looking at patents and how things are shifting, particularly in a really dynamic place like South Korea. Yeah, our focus for this deep dive is super specific, but honestly, it has huge implications. We're talking about how South Korean patent offices and the courts figure out the inventive step of an invention. And we're really zeroing in on two connected ideas: the effect of invention, what it does, and this sometimes controversial use of data that gets submitted after the patent application first goes in. So our mission here is to pull out the most critical nuggets from some really interesting sources we've looked at. We want to give you a clear path to understanding these tricky legal points. We'll dig into some surprising facts maybe, and definitely explore what this means in the real world for anyone involved in creating new things, ready to explore. Okay, so let's unpack this first bit. Effects described in the specification. What are we actually talking about here? In a patent application, this basically refers to the benefits, right? The outcomes of your invention.
Exactly. It's what your invention does and, crucially, why that matters. It's not just fluff. These stated effects are absolutely fundamental when deciding if an invention has that inventive step, meaning it isn't just obvious to someone who already knows the field.
Right. But you can't just say it does something amazing, can you? There has to be some foundation for it.
That's the critical part. While those described effects are vital, there has to be what they call a minimal basis for it already in that initial patent document, the specification. And this is exactly where supplemental data submitted later, or, post-filing data, comes into play. The massive question, the one where South Korean law has really, really pivoted, is when can you actually use that later data to back up those effects you initially described, or maybe even just hinted at?
And historically, South Korea was known for being pretty tough on this, wasn't it?
Yeah.
Much stricter than, say, the U.S. or Europe.
Oh, incredibly strict. Yeah, compared to the U.S. and Europe, it was a much harder line. If the data wasn't in the original filing, you often had a real uphill battle making arguments based on it later. But as you said, what we're digging into reveals some, pretty significant recent shifts away from that.
Okay, so how does this play out with specific types of inventions? You mentioned things like selection inventions.
Right. So previously, Korea wasn't quick to recognize what's called difficulty in establishing the configuration for certain types, like selection inventions or, say, new crystalline forms of known substances. But that's really changed. Now, the difficulty in actually finding that specific configuration is a key factor, especially for inventions that come out of challenging follow-up research. And when they assess this difficulty of composition, especially with those complex Markush form chemical formulas.
The ones that cover potentially loads of compounds under one umbrella structure.
Right. Exactly. Like a choose-your-own adventure for chemists, potentially covering thousands of compounds. The Supreme Court now takes a really comprehensive look. They weigh the sheer number of possibilities, whether there was any hint or motivation in the prior art for someone skilled to pick that specific compound, and even how structurally similar it is to known compounds.
But it's not just about the structure being hard to find.
Right.
The effect matters too.
Absolutely. The specific effects of the invention are also seriously considered when judging inventive step. I mean, even if there's no obvious reason in the prior art to pick one compound out of thousands, if the choice seems totally random, technically meaningless, it probably won't be seen as a difficult selection. But if the invention shows unexpected or superior effects, that can be powerful evidence suggesting, hey, the selection was difficult. It wasn't just arbitrary. Especially in fields like chemistry, pharmaceuticals, where predicting effects just from looking at the structure is notoriously hard. So considering the effects becomes critical. And while a truly remarkable effect is great evidence, the courts now seem to accept that even clear improvements or advantageous effects, even if not earth-shattering, can help show that achieving that configuration was genuinely difficult.
Okay, so we've got the legal concepts laid out: effects, post-filing data, difficulty of composition. But how does this actually work in practice? When real patents and big money are involved. Let's get into the cases that really illustrate this shift.
This is where it gets really interesting, seeing the law evolve.
Right. So first up, you mentioned the Apixaban invalidation dispute. This was about chemical formulas.
Yes, a major case. The key thing here was that the original patent specification, the document they first filed, it only really described objectives and, hopes for better effects. Things like hoping for better pharmacokinetic effects, better results when used with other drugs, reducing dose fluctuations, getting more drug to the target.
But aspirations, basically.
Pretty much. Reduce side effects, lower production costs, all listed as goals. But Crucially, there was zero concrete evaluation data, no experimental results in that initial filing to prove any of it.
Okay, so the first body to look at this, the Patent Trial and Appeal Board, the PTB, what did they say?
They shut it down. They rejected using any data submitted later on. Their view was that those original descriptions were just too general, too abstract, maybe even just wishful thinking. They felt it lacked that necessary minimal basis we talked about.
But then it went higher to the Supreme Court.
It did, and the Supreme Court came to a completely different conclusion. They accepted the experimental materials that were submitted later. This later data clearly showed things like improved Zega inhibitory activity, better selectivity, real improvements in pharmacokinetics, how the drug moves through the body, absorption, distribution, metabolism, excretion, blood levels, and also showed benefits in combined administration. The court explicitly said these demonstrated effects were powerful materials suggesting difficulty in configuration.
Wow. So the Supreme Court basically said those initial hopes were enough of a basis once the later proof came in.
Effectively, yes. The Apixaban case fundamentally changed how courts look at the initial description of an invention's purpose. It's like saying, look, even if you only had aspirations and objectives at the filing date, if you can later provide solid data showing you achieved them, that can validate the inventive step. That's a huge strategic shift.
That must have sent shockwaves.
Ugh.
Okay, so that's Apixaban. Then you mentioned another case, Dapagliflozin. Similar issue, substance patent, but a different outcome or different reasoning.
Yeah, Dapagliflozin is fascinating because the conclusion was the same across the board, but the reasoning differed significantly, especially between the patent court and the Supreme Court. Here, the claimed compound was structurally quite similar to known prior art. And interestingly, everyone agreed, PT, patent court, Supreme Court, that there was no difficulty in the composition itself. The structure was considered pretty obvious.
Okay, so the structure wasn't inventive. What about the effects? Was there a difference there?
There was some difference. The data showed the claimed compound had, I think, 1.7 times better target selectivity and achieved a 58% glucose reduction in a specific test compared to a prior art compound. But the Supreme Court ultimately decided this wasn't enough. They called it insufficient to recognize a remarkable effect. They saw it as just somewhat improved effects, the kind of thing you might expect to find through routine screening, not something demonstrating non-obviousness.
So, same conclusion. No inventive step, but you said the reasoning differed. How so? This is the crucial part, right?
This is the really insightful part, yes. The patent court's logic was fundamentally about the timing of the data. They said because the original specification only described the methods for testing but gave zero results, any data submitted later just could not be used to assess inventive step. They actually called allowing it an improper preemption of the patent right, like you'd be retroactively claiming something you hadn't properly disclosed initially.
Okay, a very strict interpretation based on the original filing. How did the Supreme Court differ?
The Supreme Court was much more lenient, consistent with the Apixaban stance. They did allow the consideration of the later submitted data for the inventive step assessment, even though in this specific case, they ultimately found the effect wasn't significantly different or remarkable enough to grant inventiveness. The very fact they considered the post-filing data demonstrates their quite lenient view. They were willing to look at it, even if it didn't save the patent this time.
Fascinating. So the Supreme Court is consistently opening the door for later data, even if it doesn't always change the final decision. Okay, one more case. The Selexipag crystalline form invention. Known substance, but a new crystal form.
Exactly. The substance itself was known, but the patent was for a specific crystalline form that hadn't been described before. Initially, the PTD and the patent court found no inventive step. They basically said finding different crystal forms is just a normal research process for drug development, kind of routine. And they didn't see any significant effect arising from this particular form initially.
But let me guess, the Supreme Court disagreed again. Found inventiveness.
You guessed it. The Supreme Court overturned those decisions and found inventiveness.
Why? What was different this time?
Two main reasons from the Supreme Court. First, they actually did see difficulty in deriving this specific crystal form from the prior art. It wasn't obvious how to get it. And second, critically, they pointed to an unpredictable advantageous effect. In this case, it was improved stability. And they said this advantageous effect served as a basis to infer that the structure itself was difficult to arrive at.
Okay, stability.
Yeah.
Was that stability data in the original patent document?
No. That's the key point again. The actual stability results were not in the original specification. All the original document said was something quite general, like the raw material needed to show a consistently constant pharmacological effect.
That sounds pretty vague. How did the applicant argue that meant stability?
That was the argument. They said, look, anyone skilled in pharmaceutical arts reading a consistently constant pharmacological effect would understand that implies stability. You need a stable form for a consistent effect. Now, the PTD and patent court rejected that, saying it wasn't explicit enough. It didn't specifically say stability.
But the Supreme Court.
The Supreme Court took that very lenient approach once more. They agreed with the applicant. They said, yes, a skilled person would infer stability from that general statement. And, crucially, they then used the post-submission stability data to recognize this advantageous property when assessing the inventive step of the crystal form.
It really seems like the Supreme Court is trying to align the law with the practical realities of R&D, where you might have a goal or see a path, but not have all the final proof points on day one.
I think that's a very fair assessment. It shows a willingness to look at the whole picture, including developments after the initial filing.
So we've walked through these pivotal cases. The big question now is, what does all this mean for you, the listener, for your next patent application, your innovation strategy? Let's try to distill the key takeaways.
Okay. Well, I think the biggest takeaway, the overarching shift, is pretty clear now. South Korea's Supreme Court has become really quite comparable to the U.S. and Europe in how leniently it views post-filing data. It's a definite move away from that historically very strict position.
That's a major change. But does this newfound leniency maybe carry any hidden risks, or just upsides for applicants? What's your core advice for someone drafting a patent application now in light of these rulings?
That's a good point. There are always nuances. One could argue perhaps that this flexibility might make examination harder, needing more scrutiny of later data. But for the applicant, the main advice is this. When you're drafting your specification, if you have any general objectives, any anticipated effects, even if they're not fully proven yet, it's really advisable to describe them, even briefly. Just get something in there, because that description, however minimal, might establish the necessary basis to let you use stronger post-filing data later on to really substantiate those effects before the courts.
Okay, so lay the groundwork, even if it's just hinting at the goal. But you mentioned the lower bodies.
Right, and this is a crucial caution. This more lenient attitude from the Supreme Court hasn't necessarily fully trickled down and become standard practice at the Patent Office examiner level, or even at the PTAB yet. So, for cases that are currently pending or being filed now, applicants might still face initial rejections based on the older, stricter standards. You may need to be proactive, cite these Supreme Court rulings directly in your arguments and your written opinions, and you might need to be prepared to appeal, potentially up to the Patent Court or even the Supreme Court, to really get the benefit of this more lenient view.
So the system is still catching up, in a way. Are there still situations where having that hard data right at the beginning in the initial filing is absolutely essential, despite this general leniency?
Yes, definitely. There are exceptions. One key one is if your core invention is about a specific use for a substance that is already publicly known. In that kind of situation, the rules generally still require that the initial application must include evaluation results demonstrating that use right from the start. You can't usually add that proof later. And also, just practically speaking, even with the increased leniency, if you claim an effect difference in your specification but provide absolutely no experimental results initially, well, examiners and judges are likely just going to assume there is no actual effect difference until proven otherwise. So while post-submission data is more accepted for substantiating an effect, you really still need to plan on providing those results eventually, even if the data itself is formally submitted later on. Don't rely on just words.
Makes sense. And what about litigation? How does this uncertainty about using later data affect trying to predict the outcome of a patent dispute?
It makes predicting outcomes considerably difficult, to use the language from one of our sources. It really does. Because the judgment might hinge heavily on data that wasn't available or even known at the time the dispute started. You don't know what might be presented later. From the patent holder side, this can be an advantage. Submitting strong post-filing data could potentially let them overturn an unfavorable situation that might have looked pretty bleak based only on the initial filing and prior art. It adds a dynamic element.
Any final practical tips on how to submit this later data?
Yeah, a couple of things. Sometimes this post-submission data can also help meet other requirements, like the support requirement, maybe by providing more examples that back up the scope of your claims. This varies a bit depending on the type of invention, though, and also a practical point. If confidentiality is a worry, which it often is with unpublished experimental data, It's usually advisable to submit detailed experimental results as attached documents to your arguments, rather than putting all the sensitive details directly into the main body of your public written opinions filed with the patent office or court.
Okay, so we've really traced this fascinating evolution, haven't we? South Korean patent law on effective invention and post-filing data moving much closer to international norms, showing significant judicial flexibility.
Absolutely. And understanding this shift is strategically vital for, well, for innovators, for companies, for the legal practitioners advising them. Adapting patent strategies to reflect this reality is key because, knowledge is great, but it's most valuable when you actually understand it and can apply it effectively. It really shows the legal system trying to keep pace with how innovation often happens iteratively.
It really does. So as we wrap up this deep dive, here's something to think about. How might this increasing flexibility from the courts actually influence innovation itself? Could it encourage more exploratory research, maybe allowing companies to file earlier, even when the concrete results aren't fully locked down yet? What stands out to you as the most surprising part of this legal journey we've discussed? Lots to ponder there.